This is case B15519-168. We have the parties and counsel present. For the video record, would you please confirm appearance?
Chairman, member of the planning board number 02461 and Mr. Burns are present.
Morning, Your Honor. Michael Balaban, bond number 4436, appearing on behalf of the defendant, is present.
Parties have a seat.
Mr. Balbon, I appreciate you filing a response in opposition. I also understand that you filed a motion to withdraw and the court granted an order shortening time today.
I'll withdraw that motion, Your Honor.
Are you sure?
Yes, Your Honor.
Then just, Kathy, if you just note that Mr. Balbon's motion to withdraw is withdrawn. Okay? The court tried this matter in February. We had the findings and custody decree entered in March. And on May 23rd, the plaintiff filed a motion alleging a denial of visitation over spring break. The court reviewed the opposition to counter motion, and I'm prepared to hear your points. Mr. Reed, you read the opposition. She describes a dispute concerning a pickup on a Friday, that he came on a Saturday, and that the exchange didn't take place. I know that it was just filed on the 23rd. I didn't see a reply this morning. Do you want to just tell me what happened from your client's point of view?
Yes, Your Honor. And I'll be brief as always. First of all, we didn't get the opposition until Friday, and this is one of several times this has happened. I can only believe it's sandbagging. She says two interesting things in her opposition. Well, first of all, the court may recall this case. You have a March 9th order. We had an extensive evidentiary hearing. The court made certain specific findings of fact, and that's why we believe that we asked the court in the alternative to reconsider. The court found moderate conflict. Danielle would learn to co-parent with Jason. Danielle would follow the court's orders. This is after. And the court believed her, and that she would obey the court's orders. Not the court's fault. And so she testified at the hearing, which was 2 days, that she would obey the court's orders after admitting in December. This is the second time this has happened in less than 3 months. As the court will recall, in December of 2015, she admitted on the stand, denying him his visitation. Since he lives about 6 hours away in California, or longer, it's quite a serious thing. And she said she wouldn't do it again, and that's it. So you signed the order on March 9th, it was filed, and then my client was supposed to have a standard spring break, March 19th to the 28th, I believe. And so he texted her. I'm looking at texts. This is what we would have given you. I'm looking at texts on the 18th saying, you know, I'll have my mother come by. First of all, he said, I'll have my dad come by, granddad, which the child loves. The child loves both the granddad and grandma. And she says, no, it's not in the judge's March 9th order. In fact, there was a prior order that I sent to opposing counsel during litigation. He never got back to me, never signed it. So I made sure I prepared that, had the court sign it. Now, it was filed on April 21st, saying he has to give her knowledge of who's going to be the pickup. And the point is, on the 18th, he texted her saying, well, Carol, my grandma will pick up the child. And she said, no. I'm looking at text, quote, only you, not your mommy, nobody else can pick up. No, not you, I don't share custody with your mom. This is on the 18th, late on the 18th. And so we said, okay, well, I'll be by on the 20th to pick up the child. He's supposed to pick up his mom was supposed to pick up the child on the 19th, but she wouldn't allow that. So he says, okay, I'll be there on the 20th. She agrees. She says, okay, but just pick him up before 8 o'clock, 8 p.m. So he gets there before 8 p.m., and according to her opposition, she says two things that are not true. First of all, on page 1, actually on page 2, line 26, she said, then, quote, Danielle specifically denies refusing Jason his custodial time for the spring break period. Well, that's not accurate, because in her affidavit, she doesn't specifically deny anything.
The opposition says that she thought he should watch a movie before.
Well, right, and I'll get there. You know, I just wanted to emphasize the fact.
But you said you were going to be brief.
I'll move on. You know. And so she says in her opposition on page 3 that says, once he gets there from California, she says, before 8 o'clock, she says, well, the movie's starting at 8. He really wants to watch it. She invites him in the house. course, he says you never invited him in the house. I have an email here saying I don't want you anywhere near my house. You can't come up to my door, but that's beside the point. That's what we would have filed had we had time, because our whole opposition is untimely. So she wants him to wait there for 2 hours while the boy finishes a movie, and then she says to him, in her opposition, Danielle also offered for Jason to return the following morning. That's her explanation, which both are violations of the order. She's not supposed to say, wait for 2 hours for Dustin to finish a movie, that's a violation, or, hey, come on back tomorrow. So what he did was he called the police. One of the officers that we could subpoena, if there's going to be an evidentiary hearing, if she still sticks to her story that she didn't refuse, Officer Poposta, and 2 officers came out and read her your order. They read her in my client's presence. They read her your order. And she still refused. My client says she was intoxicated. We would ask for drug testing today. So for her to say now to you, I didn't violate your order. We have now independent witnesses that we represent can come to court and testify to the exact opposite. In other words, she lied in her opposition. She lied because we believe she feels empowered. Moving on. So that's contempt. We ask for 7 days and attorney's fees. And we also asked that she give them a list of medical providers. You suggested it before. It didn't quite make it to the orders. I think it's a good idea. And the birth certificate. Next issue is she texted him after your order in March. She texted him saying the boy had a suicide ideation. And actually it was March 7th. The order was signed March 9th, but it was after the evidentiary hearing. He gets all upset, wants to know what's going on. Gee, what doctor are you taking him to? Please tell me, keep me posted. And this is what fuels his desire to have the medical and healthcare, mental health providers, because he's scared for his son, because he was in her care at the time. The third thing is that the grades, the court has seen their latest. In your findings, you found that she, and I have it, the reason why I lay it out here is because the court relied on testimony. You find that things will get better. That she'll finally take him to school, she'll finally work with the school authorities to make sure he's taken to school, and he graduates. Well, now all that is in jeopardy. Nothing at all has changed. It's still the same. 40 absences this year, 40. So that's the third point we would ask the court to consider with regard to our alternative request. And the fourth thing is on June 15th, the court knows that my client has Dustin now for 6 weeks. And she wanted him to return Dustin, so she got angry at him, and what she did on June 15th is she called the police in California, claiming that my client is abusing an autistic child. So they came out, they checked it out, nothing going on, and they left. So we would allege she's trying to manipulate, and this is in his supplemental affidavit that I filed, because it's important. Not only has she denied him here, but she's harassing him in California, which she should not do. It goes contrary to your findings that she's going to work with him, she's going to, consistent with joint legal custody, she's going to co-parent, she has absolutely no intent. So those are the 4 things that have arisen since your order, since the evidentiary hearing. The suicide ideation, 3/7, the spring break, 19 through 27. And I would note to the court, that's the same month that you issued your order on March 9th. The grades, still absences, and then fourth is the IEP. Your Honor, as the court probably knows, there's been a lot of discussion in opposition. She was supposed to meet with the school in June to make sure he's enrolled in the 2016-2017 year. Well, she missed that. For some reason, she blames my client. I don't understand that at all, but she does. She blames my client. My client was informed about that, and so now she says she's going to reschedule for July. The point is, we would allege the court We asked the court to reconsider. They say in their opposition, well, you know, you didn't bring up anything important. You didn't bring up intentional acts or any reason to justify our 60B motion for mistake. Well, it's very simple. It's a very simple concept. She represented certain things at trial, and naturally, the court has a right to take a party's word for it. You did. And it turns out to be false. It's false that she wants to work with him. It's false that she will obey your orders. We believe she feels empowered at this point. You aren't going to do one single thing. So we would assert her opposition proves that she denied him for the week of spring break. Their explanation is certainly not exculpatory. And for them to say that he's not acting in good faith in their opposition because he doesn't want to wait 2 hours. Actually, it took 3 hours for the cops to come. So now it's beyond the movie period. When they came, they read her your order, and she still refused. So her representations that all she wanted to do was have him wait for 2 hours till the end of the movie, or maybe he should come back the next day, is completely false. And he doesn't have to do that. That's why we came to court in the first place. So in sum, Your Honor, if the court believes this is enough, you know, 4 things: the suicide ideation since the evidentiary hearing, the denial of visitation for 1 week, which is, we argue, supported by her affidavit, and if she still sticks to her story that she didn't deny him, we want you to set an evidentiary hearing. I will subpoena both cops, and we will leave it, if that's her position, we will leave it there.
Mr. Balaban.
With regard to the, get rid of some of the stuff that's take less time, the suicide ideation thing, the child apparently reflected some sort of sentiment that he overheard another child say in the school. She texted him. She thought it was something that he needed to know about. They had a discussion surrounding that issue. There were no indications by either party that they felt a medical intervention was necessary, and none was taken. That is not denied today. There is no medical provider that she refused to disclose. The fact is, she texted him about the issue, which is evidence of compliance with the court's order. What we have here in this situation, Your Honor, is we have a mother who has been caring for a special needs child for 7 years. I think the court needs to understand the overall context to understand what's happening now.
You don't think spending 6 hours with these folks helps me understand what's going on with these
Okay,
folks?
well, as long as you understand, then that's fantastic.
Well, I mean,
But she
I
has,
wrote a how many page order?
yes, I
explaining the
understand that,
findings
Your
and
Honor.
conclusions in this
Then
case?
I will not go into that. All I'm saying is, what's going on now in the 6-week period is mom is understandably upset and concerned because the plaintiff has displayed since the hearing nothing but contempt and hatred towards the mom. It's impossible to co-parent in good faith when you're being called names, you're being called a drug addict, you're being called a freak. I don't know how they can expect really good faith cooperation in return. With regard to the exchange that occurred or that didn't occur, you know, at what point, he was supposed to show up on the Friday. He didn't show up on Friday. He tries to make unilateral text message communications with her. Okay, so-and-so is going to pick up the child. She's not required to do that by the terms of the order. She is required to allow the mother. I'm not familiar with what happened with regard to the exchanges with the mother on the Saturday that followed the Friday. The bottom line is he didn't show up when he was supposed to show up. If he shows up on Wednesday at 5 in the afternoon, is she just supposed to, okay, here you go. I mean, this child requires some time to package and get ready. He has medications. He can't just show up when he feels like it at a time that's other than that which is stated in the order and say, okay, I want my child. My client is pretty adamant that she was very friendly with him when he first arrived and said, he has been looking forward to watching this movie for quite some time now. You can come in and watch it with us and then you can take him. He refused instead, again, I believe with the intent to try to come back in here and find a reason to overturn your order. I believe that's why he said, oh, okay, I'm just calling the cops. I'm not going to do anything that you say. I believe that is the source of the conflict. Had there been good faith communication and cooperation between both parties, we wouldn't be here right now. She did offer him to come back the next day to pick up the child. Rather than do that, He just says, oh, I'm gonna file a motion to hold you in contempt. He could have had his whole week. He chose not to take it. Her story is what it is. I'm not going to elaborate. That's her story. The suicide ideation with regard to the school, she doesn't blame. She blames the school district for not providing her with notice of that hearing that he appeared at. The reason I put that in there was he stated in his motion that he's not being notified of school events. Well, actually, he is. He's on the school list. I don't know what that thing's called. Whatever it's called. He's on there, and he was obviously notified of this hearing. So to blame her for that again is ridiculous. So they're all red herrings, Your Honor. The 60B motion based on fraud is clearly a red herring. They haven't stated a sufficient case for a change in custody that would justify an evidentiary hearing under Rooney. And for these reasons, we would ask that the motion be denied. The kid's coming back in 2 weeks. I don't know if he's going to allow her to see the kid today. I mean, she obviously has had concerns with the kid. And, you know, I understand what the court's order is. She understands what the court's order is. She will comply with the court's order, just as she has complied with the court order, because the child is, in fact, with Dad in California now and has been for 4 weeks.
Thank you. Mr. Root, did the child travel here with Dad?
Yes, sir.
When is your client planning on going home?
I have work early tomorrow morning, so I'll
So
be
you're
going
leaving
home.
after the hearing?
Probably, I would want to beat the traffic a little bit, you know,
What time do you plan on getting home around?
maybe 3:30.
Okay, that's fine. The,
Can I make a couple of points, Your Honor?
please.
Yes, Your Honor. Just, and I will be brief. First of all, she is required to follow the court order. I was just looking at the court's April 21st order. Lines 18, 19, is further ordered that plaintiff's mother can help with the child as long as defendant is aware of it. I have her texts saying right before the 19th, when he was supposed to pick up the child, that she just simply refused. Carol, grandma, was supposed to pick up the child. And we made this point before. If Carol's allowed to pick up the child, she can go halfway, my client can go halfway. It's better for everybody. So it's not true that it's not part of the court's order. It is ordered, and they should know that. I don't know what they mean when they say that he displays contempt and hatred, free calls names. My client doesn't do any of that, and I can't read that in their opposition. I mean, if I'm wrong, I'd like the court to point it out to me, but it's not there. Thirdly, the reason why I took a long time in the motion to go over the court's findings was because the court found things based upon her testimony that she would follow your orders and she would cooperate and co-parent. And the court found, for example, on page 9 of the order, parties will cooperate and work together for Dustin's, through that experience, Dustin needs engaged, committed, and dedicated parenting. Well, yeah, he does. The court, and then the court found that moderate conflict, well, we would not agree with that, but...
Why would you, come on, you don't need to read a 21-page order. I wrote it, okay? I know it.
And in summing up, Your Honor, I would just submit it to the court.
All right. The court has jurisdiction to enforce the orders that have been entered and to consider requests to modify them, okay? Before I go over the findings and orders, what's your client's schedule today? Do you know, Mr. Balaban?
She's
Are you
open
working today? You're not working?
No, I
She
still
doesn't work here.
All right. You've asked for two things. You've asked her to be held accountable for what happened in May, and you've asked to essentially set aside the decision from the trial, okay? But there's no merit to the request to set aside or to modify the judgment of the court, even if everything that Dad said related to the circumstances in May are true. Not because what happened for spring break is consistent with the order, or that it was appropriate, or that it was showed good judgment by Mom, but because on balance the case was decided and closed, and the court to reopen or relitigate custody, something material has to change. Okay. Now for Dad, he invested time and probably had a lot of emotional heartache about not getting his child over spring break. I don't want to minimize that, but there's no adequate cost to set aside under Rule 60B, and there's no adequate cost to reopen to litigate a modification of the custody order. Okay. That being said, I expect the parties to follow the custody order. It seems about as clear as day. We have a decision which talked about all the problems. We heard testimony concerning the problems between these folks, and they had an opportunity to have a fresh start with the closure of this case. The court understands that not everything is agreed as to what happened during spring break, but it's easy for the court to find, without having any kind of evidentiary proceeding, that mom's decisions were flawed and in violation of the order. They were wrongful. She wrongfully denied Dad an opportunity to receive the child as ordered for spring break. Her decisions or reasoning, I understand from her perspective, she wants to share those reasonings, and but to have a denial of a physical exchange because the child wants to watch a movie a day after Dad was supposed to get him is not an excuse, not valid at all, and she's accountable for that. She denied him ordered contact, and the remedy in the statute for that is compensatory time and a consideration of sanctions. The warning here is that the order talked about all the difficulties that these folks have had concerning the parenting, and essentially reset with the custody order. I'm telling your client, Mr. Balabon, in the clearest possible terms that we just create, from we start that case over, we create a record of facts and circumstances that constitute a basis for the court to consider whether to reopen or not. And this is a misstep by her. It's a misstep by her that's not going to result in me really getting the case now, but it's going to be part of the context as we look ahead to see whether or not she can be entrusted that primary custody of this child. She's to follow the orders in all respects. He had to, I made him come all the way here to get the child, and he didn't get the child. The sanction, Mr. Root, is going to be a $500 sanction for violation of the order. Because of the financial circumstances, the court is going to allow him to essentially be paid the sanction with a reduction in this child support of $250 for the months of July and August. Pay $561, $250 both months. The remedy is makeup time, and I can't give you back spring break. I'm sorry about that, but the court is going to extend your summertime 7 particular days. Okay? I would like Mom to see the child today. 6 weeks is a long time to be without Mom. If you're not planning on getting on the road till 2 or 3, noon to 2 would be what I would propose.
I can push it.
Ma'am, do you want to go to lunch, hang out with your son for a couple hours?
Absolutely.
All right. So just so we don't have any fights or disputes, can we have an exchange maybe at the family court at noon, and you return at the family court at 2?
Absolutely.
All right, that's what we'll do. Visit with your son. Tell him to enjoy the visit, and then he'll be back in a few weeks.
Yeah.
Okay. Since I don't have an order, and I'm trusting you guys to follow the rules, be on time for the pickups and drop-offs today.
So this doesn't happen in the future. Can we have you order again that he can use grandma or grandpa?
The use of a reasonable agent is not prescribed. In other words, well, look, she's in more trouble because of her decision and what she did when Dad actually did show up the next day, as she was not allowing the mother. If I had gotten an evidentiary hearing, I would have looked at the email communication and seen whether or not it was reasonable. I don't need to do that. I'm not going to. I'm telling Mom.
I just thought I'd hear that, Your Honor. So
Yeah.
we have an order now.
All right, Mr. Balabon, before I jump in on that, is there anything about his mom or his dad or whoever would be helping him pick up that she has issues with as far as safety or fitness? I don't remember any evidence concerning that. Do you know?
In terms of safety or fitness, no.
Well, I mean, it's reasonable for a parent to use an agent, on occasion. I think that I would probably side with Mom generally that Dad should do the transfers. But, the other thing is he lives out of state. So is there anything about his mom that would help me understand what her reluctance would be? I mean, does she have a driver's license? What's the deal?
Hi. What goes on is I get a lot of tag teamed by the dad and the grandmother. The grandmother wanted to plan.
Will you let her see the child?
Yes, I do.
All right.
Yes, I do.
So why can't she facilitate an exchange?
Because the trouble that the confrontation, she wants to plan out the child's, give me his information of what they're going to do. She oversteps her boundaries too much.
Okay, that's fine. Look, one of the things that she wanted the court to understand was, she wasn't trying to cut off the paternal side of the family. She allowed visits. You don't have to stand. You can sit down. Yes, Mr. Root, the dad's mom is suitable to allow to facilitate custody transfers on the front end of the back end.
Thank you.
We're done. Mr. Balaban, I appreciate you sticking with your client, and you'll be given the opportunity to read the phone call under your order. Okay?
Did the court think about the drug test request on that?
Not very long. All that other relief is behind.
Yes, ma'am. Thank you. I'll prepare and send it over to you.
Thank you very much.
Okay.
Thank you.
Behind is on